Hello, and welcome back to our blog and audio series, Defending the Algorithm, a Bayesian analysis of AI litigation and law. This episode number 4 is entitled The Daily Routine, Practicum for Using AI Tools in Context in Business and IP Litigation. I'm Henry Sneath, and I wrote, edited, and I'm narrating this blog post. I practice law in Pittsburgh, Pennsylvania with the law firm of Houston Harbaugh, and I specialize in business and intellectual property litigation with a heavy emphasis on patents, trade secrets, and employment non-competes and restrictive covenants. Both the practice of law itself and the substantive law in many areas are being heavily impacted by the growing presence of artificial intelligence in all areas of business. This series is examining the effect on both the substantive law and the technical practice of law. I was assisted in research and writing this post by Claude from Anthropic, Sun Edition 4.5 Pro, and some research confirmation and assistance from Google Gemini 2.5 Flash and Westlaw Precision AI. All platforms can make mistakes, but I've taken care to check this post for accuracy. Here is our introduction. In this Defending the Algorithm blog and audio series, we've examined the important Bartz v. Anthropic copyright settlement, explored the expanding legal battleground over AI training data beyond copyright claims, and calculated trade secret litigation probabilities. Throughout these analyses, I've disclosed that I use AI tools extensively in my legal practice, from researching and writing pleadings, briefs, and strategy memos, to writing these posts and creating marketing materials. Obviously, we all use AI to manage our daily litigation workload, to sort and filter emails, to store documents to files, and to manage and generate large document reviews, analyses, coding, and the production of documents, and other major document issues. Consider this a practicum, if you will, a practical guide demonstrating that thoughtful AI implementation involving proper information management, Bayesian thinking, and rigorous user training can enhance rather than replace or compromise the quality of legal services. This raises an important question that I frequently hear from lawyers at CLE programs, from business clients, and in conversation with other practitioners. Exactly how are you using AI in your practice day to day? What are the specific tools, and how far can you really go with AI in the law? The answer matters because lawyers and clients seek efficiency, cost savings, and great litigation results. But we all face unique professional responsibilities relating to competence, confidentiality, and candor that shape how we can ethically deploy these powerful tools. This post shifts the series from our prior theoretical analysis to a practical application. I'll walk you through my actual daily workflow as a trial lawyer, actively using AI in our tech stack across nearly every aspect of practice, from predictive analytics that inform strategic decisions to context-aware research tools that transform how I analyze cases. The critical insight that I've learned through trial and error: successful AI implementation depends on how well you've prepared your practice's information ecosystem to support it. They always say garbage in, garbage out, which is what you want to avoid. Many firms invest heavily in AI platforms while overlooking the foundational work of organizing their data, standardizing their processes, and training their people. AI isn't magic. It's a sophisticated tool that requires thoughtful integration into existing workflows and information structures. The firms seeing real results aren't necessarily using different AI platforms. They're using them differently, with better preparation and clearer understanding of how information flows through their practice and their firm's tech stack. To use Bayesian analysis to phrase it differently, the probability that lawyers will achieve AI competence to maintain their duty of technical competence under ABA Rule 1.1 at SEC, given the need for a dedicated approach to building smart and communicative data architecture, equals the amount of hard work which law firms are willing to engage in to make it happen correctly. That's the Bayesian formula of probability. Are you and the firm willing to invest time and money in the firm's tech stack to achieve excellent workflow? There is a foundational problem: why AI implementation often disappoints. That's the question for this section. Before I dive into my daily workflow routine, we need together to address a frustrating reality. Many lawyers trying AI tools find the results underwhelming. After some years of intensive AI adoption in my practice, I've learned that disappointing outcomes rarely stem from inadequate AI technology. Instead, the problem typically lies in how firms structure their information and workflows before introducing AI into the mix. And the sophistication with which lawyers use AI is important because it all depends on AI prompts by the lawyer to get the gathered data that the lawyer seeks. It's all about the prompt. Consider how experienced litigators naturally work, because we use Bayesian reasoning and prompts all the time. When evaluating a case, we don't examine documents or evidence in isolation. We instinctively connect dots across multiple dimensions, linking factual allegations to procedural requirements, assessing how specific judges have ruled on similar issues, considered the opposing party's litigation history, and we evaluate how various legal theories align with our client's broader business interests. This holistic Bayesian analysis draws on years of accumulated knowledge about how different case elements interconnect. We take prior probabilities of an outcome, blend in the new and gathered likelihood evidence and factors, and we project a posterior probability, an outcome prediction, to our clients and to litigation foes. AI systems need access to similar interconnected information to provide useful analysis. Yet many law firms offer AI tools in a fragmented landscape: separate systems for document storage, disconnected email archives, case management software that tracks deadlines but not strategic context, timekeeping databases with no link to substantive legal work or a client's CRM, and research platforms operating in complete isolation from active matters. This fragmentation in data storage, architecture, and IT coordination represents the fundamental challenge. When AI can only access isolated pieces of information from disconnected systems, it can't provide the integrated analysis that makes it valuable. It's like hiring a brilliant associate but only allowing them to read one category of documents while keeping everything else locked away. Experts have come to think of this as the information architecture challenge. Before worrying about which AI platform to purchase, firms need to examine how information flows or fails to flow through their practice and their tech stack. Where do gaps exist? Which systems don't communicate with each other? Which critical context gets lost when lawyers manually transfer information between platforms? The most successful AI implementations share a common characteristic. They occurred in firms that first invested time organizing their information infrastructure. They established consistent naming conventions, created centralized matter repositories, developed standardized intake procedures, and built connections between previously siloed systems. Only after laying this groundwork did they then introduce AI tools. which performed remarkably well because they finally had access to the connected information that they needed. Here is Chapter 1, Workflow, Litigation Research, Analytics, and Case Assessment. My typical day begins rather typically, I suspect, with opening several software systems in our IT network and on the internet. That's not unusual for most lawyers. Outlook, Juris, NetDocs, Google Gemini, Adobe Premiere Pro, RingCentral, Teams, and maybe Westlaw Precision, depending on the plans for the day. Much depends as well on whether I'm working on actual files or doing work for marketing, business development, website content, or social media. As a senior lawyer, I'd gotten away from much of the actual drafting of documents and spent my time generally supervising, editing, and commenting upon the research and writing work of others. While I'm hands-on in every aspect of a case from matter opening to trial, or being an appellee, I delegated legal research and writing to more junior lawyers with lower billing rates as part of cost management for the matters and all to the benefit of clients. I also generally delegated first-level large volume document review, coding, and analysis to junior lawyers, paralegal workers in our firm, and contract document review lawyers. So we can ask the question, well, what about the cost of using AI? Is it an accretive function? Is it efficient? While still being very mindful of the litigation spend for clients, some of that dynamic has changed due to a number of AI tools in our kit. I find myself doing more and more front-end legal research to start our team's analysis for the client and more document review, albeit generally at the 2L or 3L review level, depending on the volume and complexity of coding, tagging, and privilege issues. I'm enjoying doing front-end research to set the parameters for more detailed research on complex commercial and IP matters. I will explain this Westlaw front-end protocol in a moment. In order to make a more accurate prediction to a client at the front end, I can conduct legal research very quickly with AI myself to get the analysis moving forward very quickly. I prime the research pump at very little cost to the client, and we can therefore create and more quickly agree on a strategic case assessment. My role in document review in relativity is quick and efficient and takes far less time, meaning less cost, than lugging boxes to a conference room and shuffling paper like we used to do. Document review can only be done more efficiently with active learning, and reports can be generated showing me the pace of review by others, the number of times that documents have been marked hot docs or privileged, and the tagging of documents by issue or witness designation. All of that work makes prep for depots and trial much more efficient and less costly. While this may not be a scientific cost analysis, there are certainly areas where AI has fundamentally transformed the efficiency of my team through both AI research and writing tools and predictive analysis. Remember that none of this was needed in the so-called old days. It's only because of the dawn and evolution of emails and hundreds and hundreds of communications every day that we need to search data of this magnitude. When we say we have to search 1.5 million pages of documents, the vast majority of it is email communications in which the client spoke about relative things to the lawsuit, either with fellow employees or with the opponent corporation. In other words, the development of data and AI in the internet and in the world of Microsoft Outlook has created the need for massive document review. Here's Chapter 2, Building the Tech Stack, Specific AI Tools for the Daily IT and AI Routine. And remember, all of this post today is about proper organization of your information infrastructure so that IT platforms and AI can work together. So using your static IT tools and the more dynamic AI platforms in a coordinated and purposeful way makes all the difference. It's important to note that I do not put any client or case related data on any public platform, but I can use these platforms to hone language or presentations in a non-named case generic way. I don't name names or cases in any accessible forum outside of our dedicated network. That's an incredibly important lesson to learn. Here's a standard suite of AI and IT platforms that can be effectively used at the same time, likely with the need for multiple computer screens like I'm using right now, to create a more seamless work and information flow and better AI output. So let's start with the basic ones. Let's start with Google Gemini. Google itself at the premium level has built-in AI, which will summarize your search results and provide narrative, which helps to focus your search. The Google Gemini model is more advanced and can generate images, audio, and all things AI. I tend to use it as a primary resource for getting started with some ideas on either a legal research project or a quick check of state law in a particular jurisdiction. It learns from our interactions but will not display my personal information unless directed to do so. I also use it as a secondary resource to fact check other AI generated content and non-client materials. It is also a great interface with Google Drive in the cloud, which I use principally for marketing and networking, writing articles, blogs, and presentations, and as a portal for non-client document storage, document sharing, and content creation. Google Gemini has a relatively new tool called Canvas, which is a project-based module within Google Gemini. Claude, which I'll talk about in a moment, has a similar structure. So it's helpful to learn all of the modules that are within the Google empire, for example. In other words, the whole Google suite of products, if you sign up for a Google account and have Google Gemini, can provide an inordinate number of apps and modules to do various projects and to conduct a lot of the analysis that you need to do in your practice. So it's worth exploring these modules and examining what's behind the curtain. So in other words, I connect up various Google apps to improve efficiency, learning, and content generation. Gemini has various internal modules which put Gemini into research mode or deep thinking mode. I use these for my more complicated prompts, and the program will display notes about its thinking as the process moves forward. You don't always have to use research or deep thinking mode when you just want a quick answer. Like if you want to figure out what's the score of the Pittsburgh Steelers game as it's ongoing, you might just do the quick search. But if you want Gemini to think long and hard about your query and to help you put together a presentation, you can use Canvas, go into deep research mode, and you'll get a very thorough project. And Gemini will show you its thinking as it moves on. Claude will do that as well so that you get a running account of what the AI is analyzing moment by moment so that you can understand its methodology or stop the analysis if it's off track. There's a simple button to stop each query. This is great so that you can explain the methodology of your search if you ever need to defend the algorithm. Of course, I use various security settings to decide what I want Google to do with the data. So next, let's presume that I'm going to do some research and I would open Westlaw Precision AI Assisted Legal Research. That's an upgraded Westlaw platform that uses AI in the searching, reporting, and assisting with all things analysis about your work product. So let me explain those things and the modules in Westlaw Precision AI. Our firm upgraded our Westlaw account to the level of Westlaw Precision, and within it, we have at least the following important modules. Westlaw Precision AI Preferred with Co-Counsel Premier. Co-counsel is part of the AI that helps you draft your queries and draft the language that you're going to use in briefs and other things. The next is the Westlaw People Map. Then the Company Investigator. These are tools you can use to look up results of cases and the performance of companies in the legal marketplace and so on. Another module is a drafting assistant that can help you both with litigation documents, corporate documents, and so on. And finally, Practical Law AI Connect Preferred Dynamic. Corporate lawyers rave about it in helping them put together corporate documents. I can use it by prompting it to generate a set of interrogatories for a typical patent case. And I can then put in prompts and certain parameters to make the draft of interrogatories more specific. So this Westlaw has many features which make it a very robust AI platform and which therefore helps to augment, not to replace, our legal analytics and client service. AI tools like Gemini and Claude will admit that they cannot find certain case opinions and analysis like a human legal researcher because they do not have access to closed databases like Westlaw, Lexis, and Bloomberg Law. Therefore, it improves the process to work with both your favorite AI program and Westlaw together to produce superior work product. This is in keeping with the concept of building proper infrastructure for your work, and it requires the discipline to cross-platform to ensure research accuracy and great writing. Remember, it's all about organizing your information infrastructure so that AI can do its work. The good news about Westlaw or Lexis is that they use AI to search their own massive historical legal data and not the web. The chance for hallucination is lessened, and even if there is a mistake in the AI interpretation, it will not likely be coming from an outside source. However, everything has to be checked by a human, that is. Westlaw has many features which produce litigation analytics. That's one of the modules that could never be generated by a human legal researcher, even if they had unlimited time. You can conduct research to determine the case histories and likelihood of certain rulings by a judge. You can research the litigation history, experience level, and litigation results of opposing counsels and their law firms. Litigation analytics are available by court, judge, lawyer, case type, and other categories. These are litigation statistics, which makes it particularly useful for my work as a trial lawyer. Reports can be downloaded or emailed directly to clients and team members. I run these reports to jumpstart our initial case analysis, and I run some of the analysis through other AI for extra context and analysis suggestions. AI only works well when it is given context. That's an important characteristic of this process. So I can decide immediately upon case opening on the scope of legal research for that new case in minutes and email the full report of the case law on the issue by relevant jurisdiction or judge to the client or to members of my team on the case. In other words, I'm not sending an associate on a random search, but can save the client money and hopefully produce better results by assigning research that's already been jump-started for the case in general or for a specific motion to dismiss or later motion for summary judgment. An especially important Westlaw analytics tool is a search of all of the references for opposing counsel to help gauge his or her experience in particular matters. For me, there are over 1,100 case references from multiple, albeit available and electronic, federal and state court documents where judicial opinions and rulings in my cases are posted. Any opposing counsel can review that case history of mine to assist in evaluating my capabilities and tendencies with regard to the types of pleadings and motions that I file, the types of results that I get, and the level of my experience in various substantive law areas. This is all within the Westlaw Analytics tool in AI Precision for Westlaw. Another important tool in Westlaw, and this is really a good one, is the Quick Check module, which allows you to get analysis and comment from Westlaw AI on your draft brief or your opponent's brief. In each case, it can do a friendly review to help you strengthen your own brief. In other words, provide suggestions to your draft brief on how to beef it up. Or it can provide an unfriendly, as in adversarial review, to critique your own brief or that of your opponent. In other words, you can mimic your opponent's look at your brief to see what they're going to say, and you can plug in your opponent's brief and ask for an adversarial review to help you build your counterargument. In a third application, and this is the cool one, I think, you can enter both your own brief and that of your opponent and get a judicial review, which is described as mimicking the review done by the court or its law clerk. Multiple briefs can be entered at one time for complete review of all briefing, even in multi-party litigation. It's like having mock oral argument on the issue. With all of these tools, reports are generated by AI so that you can provide your client and the litigation team with analysis and recommendations. Now let's go back then to what I and many other lawyers open every day for management of our schedules and our workload. Typically, I open, again, like many lawyers, Microsoft Outlook, Microsoft Teams, Ring Central, and NetDocs. These tools do not require much description or explanation, as most people are very familiar with them or something very similar. They guide me through the day with their basic functions and AI tools, and NetDocs stores case files and client-related documents. I have the Microsoft Teams model open all day and the Ring Central phone app open within the Teams platform. They are both constantly interfacing and syncing with Outlook, Microsoft 365 Office, and right into the calendars, tasks, and contacts so that I have an integrated communications network and well-managed flow of scheduling and information. That tech stack integration is very important. As our firm has searched for new products, we always ask, is it interactive with Microsoft? Will it work in coordination with our phone system? Will it work with NetDocs? We work very hard in our firm, and our IT people do a great job of finding products that work with each other to particularly allow the AI functions to be at very high level. In our firm, we no longer have landlines, but we have Ring Central, which manages communications on my laptop, mobile phone, and tablet. Unlike texting on a cell phone with no good way to preserve, store, or manage texts, we can now do texting for business use as it is stored in these apps. We are texting literally from what used to be our landline direct dial number and not from our cell phone. We are using these tools more and more for inter-office communications as well. Texting makes the millennials happy, so we can do it, but in a business savvy and business safe way. Microsoft Copilot AI also assists with programming and management of communications and video meetings, and the AI voice recognition models allows the team Ring Central platforms to generate recordings, notes, and meeting or call summaries where permitted by law or agreement of the parties. In other words, it has great voice recognition, will generate notes and a summary of your call or of any meeting that you do through Ring Central. There are numerous other workflow apps in the Teams and Ring Central module, so office communications done through the laptop are closely akin to communicating with apps on a mobile device. NetDocs is the backbone of our case and document management system, but it is not designed for being a repository of large document loads. NetDocs is for management of case file documents, pleadings, correspondence, and so on, that are generally single documents, even with exhibits, but everything is essentially stored as a single document. It's a great management system, but you just don't dump a large tranche of documents into NetDocs. So we use certain network drives, standalone servers for large document storage, and we use relativity to manage document review, coding, tagging, and production. I'll talk more about relativity in a minute. All of this is done over the internet. All of our interface with our office is done over the internet, so it's accessible everywhere. We've done a good job in the firm with our tech people of moving things to the cloud. The goal is easy access from anywhere, integrated workflow, excellent communications, daily schedule management, case management, and good organization of data, research, and client support through these AI tools. For writing and strategy, and for generation of presentations and slide decks, I heavily rely on my friend Claude by Anthropic Sonnet Edition 4.5 Max. Claude was named after Claude Shannon, who lived from 1916 to 2001 and who is deemed by many to be the father of information technology. This AI tool has become a workhorse for my practice, particularly in business development efforts. I recently upgraded my plan to provide more Claude AI space, more data storage space in which to work, because like most AI platforms, the number of tokens which can be generated by user input is limited in different ways. A token is a certain small number of characters of text, which is how AI works. It works in tokens. To explain the concept further, let's look at a 280 character tweet on Twitter, now X, but they still call them tweets. A single tweet doesn't have a fixed number of tokens, as it depends on the content, but a rough estimate is that a tweet is fewer than 100 tokens. This is because for English text, one token is approximately equal to 3/4 of a word, and a tweet has a maximum of 280 characters for standard users. Therefore, 280 characters is roughly 70 words, or about 90 to 95 tokens. Anyway, some AI platforms will limit the number of tokens that you may use unless you upgrade the platform and purchase more. So it's good to look into the parameters of the AI programs you're using to see how much data they will let you input, how long you're allowed to make your prompts, basically your questions, your inquiries for information. All of those things may be limited in the number of tokens, so you should scope that out in advance. I use Claude to build databases for projects and certain legal issues on which I consistently work. For example, I have a database on intellectual property issues in general, one on patents and one on trade secrets. And I have another database set up solely for the purposes of helping to generate this series of blog posts on defending the algorithm. I upload public documents, case opinions, and topical articles into the platform. Then, if I write on a topic, or I want to do a blog post or a podcast, I can have Claude work in the same database project to analyze and assist in writing the piece. I then have all case sites and references checked in Westlaw, and of course, I certify that my eyes or some other competent human eyes have checked all of the final results before publication. Some courts indeed are now requiring actual sworn certificates relating to the use of AI and the fact that the work product underwent human review. You have to provide a certificate at the end certifying that a human reviewed all the case sites and opinions. I don't upload any confidential or client and case-specific materials to Claude or any other public database. While Claude is specific to my work, stores information only about me in the database that I create, and promises security, I don't take any chances. While I continue to store external case opinions, research results, and project information on our own network servers, I now can upload copies of those materials to Claude and Google Drive and have a dynamic and interactive database experience, including Westlaw Precision, where AI analysis can be done. That will not happen on our static network servers. As I mentioned earlier, good output from AI tools requires a firm-wide proactive approach to information management, workflow, and connectivity of platforms. The more that these AI platforms can be connected, even with non-AI platforms, then so much the better for the expected output. Here's Chapter 3. Document and data collection, review, and production. We use Relativity. It is one of the premier document review platforms out there. While document management systems of various kinds are well known to litigation lawyers, I want to focus on the management aspect of the large document review and production projects and the coordination of document management systems like Relativity with the law firm's other IT tools. Managing large document projects for gathering, housing, sorting, batching, reviewing, coding, tagging, and producing documents is an art, and a plan must be included in the very first substantive conversation with a client. The client needs to understand what a massive data review process will cost and how long it will take, and what are the expected results. What is the work product from that document process? This process management by a lawyer is a valuable skill because if it's done right, it often gives your side a huge advantage if the other side is not so savvy with large document management. If it goes wrong, it can really spoil a case both on the cost side and the results side. It also impresses the judge when you're defending your discovery compliance if it is in any way challenged by the other side. Judges now mandate and enforce detailed and written ESI protocols as a routine part of at least federal cases, and they don't have much tolerance at all for sloppy or old document style management. Because of our firm size, we're about 40 lawyers, we don't house Relativity in-house, but we work through a dedicated vendor called BitXBit, Bit by Bit in Pittsburgh. I refer to them as BXB. I'm not sure if I'd even ever want to have it in-house because at BXB there's a large staff and multiple time zones to work with you at all times to create and customize searches and productions. They work forensically at the very front end of a trade secret misappropriation case, for example, to forensically examine, download, and maintain chain of custody of all relevant data which exists on certain drives, like those of a client's departing employee who is believed to have breached his fiduciary duty to his employer and or is believed to have downloaded company confidential or trade secret information. BXB works directly with the client and their IT folks to either remotely or in person gather all data into their servers, and they create an evidentiary initial set of the data. Then they create a working version that can be examined, reviewed, and coded so that the original set remains, well, original. The working set can be put into Relativity once there is a document management strategy established. BXB personnel will provide affidavit support to the court if it's needed on issues like evidence gathering, chain of custody, and data examination. With other AI tools, they can run initial and very detailed reports on every type of computer activity in which the departing employee engaged in the time leading up to the departure. They can tell us which websites he accessed, which dates, and how many times access was made. They can survey email traffic and, more importantly, the activity logs, which are behind the scene in Microsoft Outlook. These logs show all of the internet activity triggered by every communication. They can trace everything and can recover data from deleted spaces or in the cloud. We can all go back and look at our emails to figure out what our communications were, but behind the scenes, the activity logs say this email was generated by this server, it was sent to this server, and then it was forwarded to this server, and so on. In other words, you can trace the entire chain of that email by IP address. That's the kind of forensic exam that AI brings about. After we do that, we decide how much of that gathered forensic data is going to be loaded into relativity for review and processing and for eventual production and discovery, or in support of a pleading or motion. As the case progresses, we do discovery document production. So as the case moves forward, we receive documents from the opposing party and more documents from our client based on the document custodians that we and the client have identified as most likely to have relevant and responsive documents under Rule 26. We then work with Relativity AI to create certain strategic searches and parameters. Bit by Bit can also create overview searches for me or our team lead to monitor document review, monitor the most hit upon search terms, and other management tasks. The goal is to meet a certain probability percentage that we have gathered a sufficient number of relevant or responsive documents to comply with the rules of discovery and to pass muster with opposing counsel and certainly with the court. These statistics vary depending on the case and the volume and the nature of the documents, but we are always working with probability analysis to determine whether we have found all the documents we're looking for. We use AI active learning in relativity to continually refocus the AI on the most important and most likely responsive documents, so that eventually relativity is feeding us only the most likely responsive documents. The AI is recognizing patterns and providing us with feedback and reports. When we make a production of documents, we store that production on our own servers in a searchable database. If a case is stayed or ends with any uncertainty as to whether it will start up again, we have lesser expensive document storage options with BXB to either archive or put the data on separate large hard drives. At the case final end, we can analyze the scope of our responsibilities for destruction of confidential document data and preserve for a reasonable period of time the remaining data. Relativity AI can assist with that process as well. Yes, of course, this is an expensive process, but if it were done by a human reviewer in the modern age, it would be far more expensive and not likely to be finished in even a generous discovery time period. If AI reduces a database from 3 million pages to 1 million pages of the most likely and relevant responsive documents, it makes a huge difference in both review time and cost of review. Using AI in this context, while somewhat expensive, is indeed a financially accretive process for the client, and it allows 100 days or 120 days or 150 days of discovery time period not to be consumed simply by document review. Document gathering, review, and production needs to be managed from day one in a case, and the coordinated use of AI tools at every step, if well managed, makes accurate and efficient production of massive EI data a more likely probability. This is Chapter 4, Looking Forward, the AI Competent Lawyer. The legal profession stands at an inflection point regarding AI adoption. Within 3 years, maybe 5 years, lawyers who competently use AI tools will likely be the norm rather than the exception. The question facing today's practitioners isn't whether to adopt AI, but how to do so responsibly while fulfilling our professional obligations. My daily workflow that I've described hopefully demonstrates that thoughtful AI integration, particularly with attention to overall system-wide information organizing and Bayesian analytical frameworks, which can significantly enhance the legal practice without compromising professional responsibility. The key insight, as I see it, is treating AI as a powerful tool requiring both professional supervision and proper information infrastructure coordinated by you, by and with your IT professional. That is key. Telling your IT professional what you want to accomplish and working on great information infrastructure. The specific tools matter less than the framework for thinking about AI adoption. Enhance efficiency while maintaining competence, protect confidentiality, verify AI output, invest in organizational infrastructure, use predictive analytics for strategic advantage, and preserve the professional judgment that distinguishes lawyers from mere document production services. This requires investments in unglamorous infrastructure work that doesn't generate excitement at partnership meetings. It means consolidating systems, standardizing processes, and organizing information before deploying the latest AI features. It means teaching your team consistent practices rather than allowing everyone to develop their own disconnected workflows. But firms that make this investment, that prioritize information organization before layering AI on top, will discover that AI actually delivers on its promise. Not because they bought superior AI, but because they finally gave AI the organized, connected information it needs to provide useful analysis. The path forward requires neither blind adoption nor resistant skepticism, but thoughtful integration that serves clients while fulfilling our professional responsibilities. Welcome to the practice of law in the future, one where AI assists but doesn't replace the human judgment, ethical reasoning, and client relationship management that define our profession. But also one where that AI assistance only works if we organize our information infrastructure to support intelligent analysis. The revolution isn't primarily in the AI models themselves. Those continue improving regardless of what lawyers do. The revolution is finally organizing our information and workflows to support that intelligent analysis that comes from human attorneys, artificial intelligence, and coordinated IT systems across all firm tech platforms. So to conclude in Bayesian probability terms with a math equation, the probability of information infrastructure organization being essential, given the evidence of competitive advantage from AI, equals very high. My thanks to Claude for its assistance with the Defending the Algorithm series. Houston Harbaugh's intellectual property and AI litigation team continues to monitor developments in training data and AI enterprise litigation across all legal frameworks. For questions about how these evolving legal standards may affect your AI deployment, your data acquisition practices, or enterprise AI risk management and litigation, please contact me, Henry Sneath, in our law office at my email address, which is sneathm@hh-law.com, or call me at 412-288-4013. This blog post represents the author's views, my views, and does not constitute legal advice. Readers should consult with qualified legal counsel regarding specific legal issues. Thanks for reading or listening, and we'll see you next time on Defending the Algorithm.